Our next speaker is William Barrett, and next up after him will be Ross Eisenbray. Good morning.
Good morning, Madam Chairman. My name is William Barrett. I'm with the law firm Williams Mullen. We are also here on behalf of our client, Universal Leaf Corporation. I'm going to split my 5 minutes actually with my partner, David Burton, and as a result, my time is very limited, so I'm just going to make a couple of brief points. I've been a management side labor lawyer since 1992 after I had left 4 years as a trial attorney with Region 14 St. Louis of the National Labor Relations Board. In 4 years at the board, I had the privilege of conducting myself at least 50 representation elections and served as hearing officer numerous times along with the normal casework of ULP investigations and trials. It's my view that our case processing of the NLRB is certainly one of the shining stars of the agency's work. I don't think it's a process that's broken. I don't think it's at all been demonstrated that there are serious delays infecting the process. I don't think we ought to have a situation where aberrational handfuls of cases affect rules that then are going to be put onto the vast majority of the rest of the work. My main concern is with what we see as potential procedural due process violations incumbent on the loss of the right to litigate potentially significant statutory and procedural issues if they are not identified in an initial position statement submitted within mere days of receiving the petition. Whether or not the employer was aware of an underground union organizing campaign prior to the petition being filed, it is almost certain that the legal issues that will be attendant to being filed with that position statement won't have been examined in any sort of depth. The chairman has talked a few times about the stereotypical size of the average employer bargaining unit of 24. That's typically a very small employer. One of the problems with that person is they get the petition. If it comes in late in the week, that owner, that manager may not be available. It takes time to get connected with the employer, and usually there's only one or two decision makers in that business. At a larger business, on the other hand, that might be an integrated operation with multiple job sites and employees in far-flung places, you have the problem that marshaling the personnel data relevant to filling out and completing all the positions on the position statement at risk of losing the ability to litigate those is a difficult process. It's not something that is a one phone call process. As a result, I think what you'll see is practitioners on the management side will throw the literal kitchen sink into these position statements in an effort to preserve all possible issues to litigate later on. It's been compared in the proposal that the civil rules of civil procedure are similar to what we're trying to do here, but as has already been noted, an answer to a complaint is due in 21 days from the filing of the complaint in the federal system, 30 days in state systems. 7 days is simply not an apt analog, especially given the fact that in an answer, sometimes your answer is we don't know. We don't have the information, and so therefore it's denied. And you always have the ability to amend the complaint here. And so the preclusive effect that it results from denying the opportunity to litigate later is going to have some severe consequences, and I think it may well result in the fact that companies, management side labor lawyers will be perhaps less likely to agree to a stipulated election agreement, which is what guides about 90% of the election work today. And I would hate to see us lose the opportunity to have the vast majority of cases litigated and processed in a timely fashion. Thank you.
Thank you very much. Mr. Burton.
Thank you. Again, my name is David Burton from the law firm of Williams Mullen, and I want to focus very quickly on the issue of post-election challenges and handling many of the representational issues post-challenge, post-election. The standard is going to be 20%. Generally, if hearing officer can determine that less than 20% of the unit is at issue, that will be decided after the tally of the ballots, subject to a challenge, if it is outcome determinative of the election. Now, anecdotally, no empirical evidence, anecdotally, generally most elections that I have worked on are decided by less than 20% of the vote. That means we're going to have a larger backdate or backlog of post-termination decisions. Now, the concern that we represent here is an issue that you do not have an informed voter. Member Hayes addressed this issue in his dissent and pointed out the Beverly case. And I think that case raises a very important issue. A voter has to decide whether or not the union is in their best interest. That decision cannot always be made if that voter does not know who or what the unit will be that he or she is voting for. Furthermore, under the Act, the employer has the right of free speech, as many people have talked about today. An important tool or an important part of the process is the employer communicating with its employees whether or not it believes that unit is appropriate for the employees. By setting this issue towards the end, after the election, employers do not know what they're going to be able to argue. They don't know what that appropriate unit will be, neither do the employees. That can create some confusion. It also possibly takes away that employee's right to exercise a free vote and understand what they are voting for. Thank you.
My colleagues have questions for either one of these speakers?
Thank you.
No. Thank you then for both of you for coming and being with us today. Our next speaker is Ross Eisenbray, and then we will conclude the morning session with Mr. Ronald Holland. Good morning.
Thank you very much, Madam Chairman. I'm Ross Eisenbray from the Economic Policy Institute. And Mr. Bell told you a few minutes ago that employees are business people making a deal. If he's right, they've been getting a raw deal, indicating that the process is flawed and they're getting bad information. Many of the employer witnesses are telling you that the rules are fine. They like them the way they are. They don't need change. That they're working perfectly, or more or less. But the Act, in my view, has been a failure in a very important way. It's failed to meet one of the fundamental purposes of the National Labor Relations Act. The way it's being administered has failed to meet one of the fundamental purposes, which is to encourage collective bargaining and help equalize the very unequal bargaining power of corporate employers and individual employees. The consequences for average workers and for the economy have been very serious. The board's rules have been tilted to favor anti-union employers. There's, in my view, an excessive weight given to the employer's rights and too little to the rights of employees and the unions. That employees are denied access to union organizers in the workplace, to information about the benefits of organizing, but they're bombarded with fear-mongering and personal intimidation by employers who know there is no effective punishment even for egregious violations of the law. You'll hear much more about this from other witnesses, including Professor Kate Bronfenbrenner of Cornell. The proposed rule will help level the playing field a little by making it easier for unions and employees